to you all and welcome to our TUPE seminar where myself and my partner Julian Hemming are going to be walking you through the latest amendments to the TUPE legislation and explaining the impact of these new changes. In terms of the agenda for the webinar, we're firstly going to be looking at an explanation of what TUPE is, the situations in which it applies, and why it is business critical to understand the rights and liabilities associated with the TUPE regulations. We'll then run through the various changes which have been made to the TUPE regulations as a consequence of amending legislation which came into effect on the 31st of January this year. There are 6 key changes and we'll talk you through each of these in turn. After examining the new changes, we'll give you some practical pointers as to steps that should be taken by way of good housekeeping to enable your businesses aptly to respond to and adequately deal with these new changes. Should you have any questions during the course of the webinar, then please feel free to post them in the question and answer panel on the bottom right-hand corner. If you direct them to Priyanka, then she will collate them, and Julian and I will aim to answer as many as we can in the time permitted at the end of our presentation. If we do run out of time, then we're happy to respond by email after the end of the webinar. So, what is TUPE and when will it apply? Well, TUPE implements European legislation which is designed to protect the continued employment of employees either on a business transfer or a service provision change from their existing employer to the new employer. So just taking each of those in turn, what's a business transfer? It's a transfer of business or part of a business that very importantly retains its identity as a going concern. So for example, it could be the sale of plant and equipment, intellectual property rights, offices, warehouse production facilities, people, all those sorts of things. So it is the sort of the standard corporate deal that you might be familiar with. In contrast to that, the service provision change is either a first generation outsourcing, second generation outsourcing, or thirdly, when services are brought back in-house. And the archetypal examples of that would be things like outsourcing of IT, canteen facilities, cleaning, security, reception, that sort of thing. So why is TUPE important? It's important for a number of reasons. Firstly, it confers automatic transfer rights on employees. So employees are automatically transferred from a transferor to a transferee on a TUPE situation. Effectively what this means is that the transferee steps into the shoes of the transferor and inherits all rights, liabilities and obligations in relation to the transferring employees. It also provides, in certain circumstances, for protection against dismissal. So essentially, in certain circumstances, it will be automatically unfair to dismiss an employee as a consequence of a TUPE transfer, either pre-transfer or post-transfer. There's also a whole raft of obligations with regard to information and consultation that need to be complied with, and if there's a failure to comply with those, then each individual employee may potentially get what's known as a protective award, which can be up to 13 weeks gross pay per employee. So in summary, getting it wrong can lead to obviously reputational risk, litigation and of course cost.
Hello everyone. We're now going to look at the 6 changes that have been introduced by the legislation that came into force on the 31st of January. So the first legal change is in the highlighted box on the left-hand side of your screen, and this goes to the question of identifying when a service provision change takes place. So these are the factors that you need to look at to see if that has happened. Are the activities to be carried out by the new service provider fundamentally the same as the activities carried out by the previous service provider? So for example, if the previous service provider was running a restaurant business with waiting staff, a menu and a chef, and the new service is going to be a sandwich bar with none of those features, the employees of the customer simply come and buy their sandwiches, there's no restaurant service, then there probably will not be a service provision change. So the government here is trying to really focus on what is the nature of the service that is transferring. Can we say that it's fundamentally the same? And if it's not, TUPE will not apply. You do need to check the current case law around this, because in addition to the legislation, there is case law that impacts on how this is interpreted. The other factors that you need to look at, moving to the right, include: does the existing service provider have an organised grouping of employees dedicated to the client? So you need to see, for example, is there a group of employees who are assigned to work on the client's activities, and when those activities are transferred to a new provider, those employees would follow that work because that is what they do. So a different situation would be, for example, if employees are organised by a shift pattern, for example, so they might be working for a number of different clients, then there may be no service provision change because they won't be organised to dedicate their work to the client who's transferring the service. Is the principal purpose carrying out the activities for the client? So again, you're looking there at the question of whether they are dedicated to that. So if the workers are performing services for multiple clients, then when one client's business transfers to a new provider, those employees may not transfer with it because they're providing services to multiple clients as opposed to being dedicated to the one client. Then does the client intend the activities to be carried out in connection with a single event or task of a short-term duration? TUPE will generally not apply where the customer wants a task to be performed for a very short period of time. For example, in the guidance that goes with TUPE, there would be no TUPE transfer in relation to security at a sporting event that was only going to last for a short period of time. You couldn't have a TUPE transfer in that situation. It needs to have some long-term to it. And finally, there will be no service provision change, or TUPE will not apply, where the customer is buying goods for its own use. So, for example, if it's buying parts to build its own product and then decides to change supplier of those parts, that will not apply in a TUPE situation. So you've got to look at what it is the customer is actually doing here. And really, service provision change is focused on the transfer of a service. So what is the impact of this change? Well, what the government is trying to do is to clarify the need to focus on the activities that were being carried out by the outgoing employer before the transfer and what is going to be done afterwards. And they're really looking to see that they are substantially the same service, be it security, back office, computer services, anything like that. Is it substantially the same? But then if there's an argument about that, employment tribunals have got discretion to decide whether or not the activities are the same. And minor differences in the activities will not avoid the application of TUPE if broadly the services that are transferring are the same. So although the law is trying to be clear here, this is a question that if it's going to be argued about will have to be decided upon by an employment tribunal, which is the UK's Labour Court.
Right, changing terms and conditions. It's, of course, very common for a transferee to want to change terms and conditions for any transferring employees that are entering their employment. And let me just talk you through what the position was prior to the changes on the 31st of January. The position then was that if it could be held that the sole or principal reason for the proposed change was the TUPE transfer itself, then that change would be absolutely void. It wouldn't matter if the parties had agreed it between themselves, if the employee had verbally or expressly in writing agreed those changes, they would just be void regardless. Also, if the proposed change was for a reason related or connected with the transfer, that would also be void unless it could be shown that there was what we commonly call an ETO reason. And an ETO reason is an economic, technical or organisational reason with some rather magic wording that has been introduced by case law, which has to entail a change in the workforce. And this has tended to be interpreted to mean a change in either numbers of employees or the functions that they undertake. Of course, a classic ETO reason is a redundancy situation where there's a reduction in the need for a number of employees. And that's the most common ETO reason that one comes across within a TUPE scenario. So that was the position pre-31st of January. You'd have to look at, first of all, distinguishing between whether the change was for a reason which was the sole or principal reason, or whether it was the change was for a reason connected with the transfer. So there was that slight sort of difference in treatment. Now, the way that things have changed is that since the 31st of January, one now has to assess whether the change is for the sole or principal reason only. So that's the only test at this point. And if it is, then, a bit like under the old law, it will be void, but now there is a potential defence. It will be void unless one can show that there is an ETO reason and that the employee consents to the change. So it's slightly different. It moves the goalpost slightly differently from the previous position. The other scenario in which it may be permissible, where the change may be valid, is where the employee's contract itself permits the change. And a sort of common example of that is where you have a mobility clause in a contract of employment that enables, or at least purports to enable, the employer to move the employee's place of work. Even under normal legal principles, one can't always rely on that. You'd have to consult with the employee and make sure it was a reasonable change if you were proposing to move them from one place to another. But potentially, if the employee's contract does permit that change, then that is something which would allow that change to be valid.
Danielle's just looked at the situation where you want to change an individual's employee's contract of employment around the time of a TUPE transfer, and another part of this second change to changing terms and conditions is linked to collective terms with trade unions. So in the UK, there are employers who agree the terms and conditions of their employees with a trade union body that they recognised. Now, the rules before the 31st of January were that the incoming employer, the transferee, must accept the employees on their existing terms and conditions, including any collectively bargained terms applying on the transfer date. So if there are terms in the collective agreement which have been negotiated between the union and the employer or a group of employers, those terms would transfer across. And also the new employer would have to recognise the trade union that had bargained those terms. So if you didn't recognise trade unions before and you were the incoming employer, you would have to recognise the trade union. Now the change that's come into place effectively is that the rules now provide that where an employer accepts employees with collectively bargained for terms, they will only be bound by those terms that apply on the transfer date. So if the new employer is not party to collective agreements in future with the trade union, and that trade union may agree terms with other employers, those terms will not impact on the new employer. So that's the first point. And the second point, which is the last one on this slide, is that the government has also provided in the new legislation that after 1 year, it's possible for the employer to agree to vary the terms and conditions that they have inherited under a collectively bargained arrangement. So, for example, the employer might want to change hours of work or pay rates, but those will still have to be negotiated. Now, the impact on the changes that Danielle and I have been talking about are these. These changes are helpful in giving increased flexibility to the new employer, the transferee, to change terms and conditions in relation to transferring employees. But remember, you do need to get employees' consent to those changes, or else they could either be void or you could be sued for breach of contract. And you've got to be careful not to break the implied term of trust and confidence. So although the government are trying to make this easier for you, you still have to be careful to seek the employee's agreement. The trade unions are unhappy with some of these changes, and there are some challenges, particularly to the ability of employers to change terms and conditions that have been collectively bargained for, and those challenges are currently going through the courts.
I mentioned earlier that the TUPE regulations provide for protection against the dismissal of employees on a TUPE transfer. The basic rule is that an employee with 2 years continuous service or 1 year if they were employed prior to the 6th of April 2012, may claim automatic unfair dismissal and or ordinary unfair dismissal dependent on the circumstances. So just taking a couple of minutes to look at the position pre the changes on the 31st of January. And a bit like when we looked at the change in terms and conditions, the way that the law was previously framed was to look at whether the reason for the dismissal was either the transfer itself or, alternately, a reason connected with the transfer. So if it was the transfer itself that prompted the dismissal, then there'd be absolutely no defence to that under the old law, and the dismissal would be automatically unfair. In slight contrast to that, if the dismissal was for a reason connected with the transfer, then it would be automatically unfair unless the employer could establish that there was an ETO reason, so an economic, technical or organisational reason entailing changes in the workforce. And as I mentioned previously, the most common ETO reason is redundancy. So under the old law, it would be possible, if there was an argument that the reason for the dismissal was a reason connected with the transfer, but that there was a redundancy situation, then it might be possible to defend an automatic unfairness in those circumstances. So what's changed? Well, for TUPE transfers taking place on or after the 31st of January, and where notice is given after that date, the question is really whether the sole or principal reason for the dismissal is the transfer itself. So that's the only thing that one needs to concern oneself with. And if it is, then it will be automatically unfair unless one can show that there is an ETO reason. And interestingly, the definition of ETO has been extended to also include a change in location, which I think is particularly useful in the context of service provision changes, where quite often on an outsourcing, it will involve a change in location for employees. And so whereas previously that wouldn't be necessarily sufficient to defend an automatic unfairness, here there's basically that opportunity to argue that that is your ETO reason, and therefore gives employers the opportunity to defend any suggestion that any consequent dismissal is automatically unfair. So the impact of these changes are that all dismissals by reason of a transfer can now be potentially justified by an ETO reason, as long as one can show that there are changes in the workforce, and as I previously mentioned, that's changes in numbers or function of the employees. So it also there's the removal of the long-standing risk when dismissing employees where the transfer requires relocation, because the definition of ETO has been extended now to include a change in location. It's important to note that if you're seeking to rely on the ETO reason, then it must be the ETO reason of the employer making the dismissal. So it's not going to be possible for, say, a transferor pre-TUPE transfer to rely on a transferee's ETO reason in order to dismiss employees prior to the transfer over. That just would not work. And importantly, I've talked about automatic unfairness. Obviously, if you have a defence to automatic unfairness, if you can show that there's an ETO reason, then that's fantastic. But that doesn't mean that, ergo, any consequent dismissal will be fair. You still need to observe all the normal go through all the normal hoops in order to establish a fair dismissal. So all that happens is you get off the hook for automatic unfairness, but an employer would still be under duty to demonstrate that they've followed all the fair and reasonable principles and that it is a fair dismissal in the circumstances.
We're now moving on to the fourth change, which I think is one of the most helpful changes that the government have introduced. And by way of background, it relates to pre-transfer collective redundancy consultation. In the UK, we have special rules that apply to collective redundancies. And a collective redundancy occurs where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days. So you need to be aware of this legislation whenever you think you might be dismissing 20 or more employees in the UK. Now, depending on the number of dismissals proposed, the collective consultation must take a minimum of 30 or 45 days. So if it's between 20 and 100 employees, you've got to consult before you make any redundancies for a minimum of 30 days, and if it's more than 100, it's for a minimum of 40 days. And the existing position was that where the incoming supplier or the buyer of a business indeed was proposing to make collective redundancies, all of the consultation would have to take place after the TUPE transfer. So you would inherit all the employees of the outgoing employer, and then you'd have to inform and consult with them about redundancy for 30 to 45 days, and then give them notice of termination. So they could well be your employees for many weeks after the transfer. So the government have looked at this issue, and now, from the 31st of January, they've introduced a very important change. And that change is to enable the incoming employer, the transferee, to undertake a pre-transfer collective redundancy consultation with the transferor's employees. So even though the new employer is not yet the employer of those employees until the transfer date, with the agreement of the outgoing employer, they can go in and inform and consult with their employees about redundancies so that the redundancies can take place close to the transfer date than was possible before. But there are a few issues with this. First of all, the transferee has got to send a written notice to the transferor. So the incoming employer has got to get the agreement of the transferor that they can go in and inform and consult with their employees, and they need to then agree with the outgoing employer that that employer will elect representatives. So it's very important that the outgoing and incoming employer reach agreement on how they're going to deal with that issue. Under the law, the transferor, the outgoing employer, is not under any obligation to provide information or other assistance to the transferee, and so without that cooperation this won't work. So it's certainly something to think about in your outsourcing or business sale agreements, to have arrangements in place for this. Furthermore, from the outgoing employer's point of view, the transferor's point of view, there is a risk that the transferee might start the consultation and then decide that they don't want to carry through with it, which would actually be very distressing to the employee. So you need to make sure there's an agreement dealing with that, and you have to be certain that the agreement you've reached is going to be concluded, or else you'll have disrupted the transferor's employees for no reason. The transferee, the incoming employer, will probably want to use the transferor's existing union representatives or other elected representatives who have been consulted with about the TUPE transfer and have been elected for that purpose. Usually want to make sure that any representatives can also be consulted with about collective redundancies, so you need to think about that whenever you're embarking on a TUPE transfer. And the new employer, the transferee, is under an obligation to ensure that the representatives of the employees are given access to the employees in order for a proper consultation to take place. And that can be problematical because, of course, the incoming employer is not yet the employer of those individuals. So again, good cooperation between the outgoing and the incoming employer is important. So what is the impact of this change? Well, it's helpful, but as you've gathered, you need to have a lot of cooperation between the outgoing employer and the incoming employer. But where you get that cooperation, it's very useful to enable a proper redundancy consultation to start at the earliest opportunity. So in fact, you can have situations where the employees are made redundant immediately upon the transfer so that they never actually start work with the new employer. And that can be very useful because the employees are familiar with the old employer and are able to be properly consulted with in a way that they feel comfortable. But you've got to make sure that you've got an agreement in place between the employers to make this work effectively.
Employee liability information. Even under the old law, there was the obligation to make certain information available pre-transfer to a transferee, and that's the items such as the identity of the employees, their ages, terms and conditions, any disciplinary grievance or litigious claims during the last 2 years. So under the old law, all that information needed to be made available by the existing employer to the potential new employer 14 days before a transfer. So the changes which are operative from the 1st of May this year are that there still must be that same provision of information, but it must now be provided slightly earlier in the process, so 28 days before a transfer rather than 14 under the old law. No change in the content of the information to be provided, so that remains as is, and also remaining as is are the special circumstances defence and the requirement to update information as things change prior to a TUPE transfer. So the impact of that change is that, of course, the transferee, the potential new employer, is guaranteed specific information at a slightly earlier stage in the transfer process than was previously the case. However, not so early that it extends to providing the sort of information that parties will quite often seek early in a due diligence or bidding process. So it won't be helpful on that front, and that would have to be something that would have to be commercially agreed between the two parties. So essentially, in terms of getting information earlier, the parties will be very much dependent on mutual cooperation.
The sixth and final change that we're going to discuss today relates to informing and consulting. As we've explained, there is an obligation on both the transferor, the outgoing employer, and the transferee, the incoming employer, to inform and consult with their employees about the impact of TUPE in good time before the transfer. So this is a the actual transfer event happening consultation. Those consultations are either with a trade union, if that employer recognises a trade union, or otherwise with employees who are elected as representatives for the purposes of consultation. Now, if you don't comply with the specific rules around consultation and TUPE, there are penalties. And the first penalty is a 13-week uncapped pay for each employee. So if employees complain they haven't been consulted with properly, each employee can get 13 weeks pay, and that is actually 90 days. And it's seen as a punitive award, so it's not a compensatory award. It's something that the tribunals hand out to punish employers who don't do this consultation properly. And to give you some context, if you've also got a collective redundancy consultation going on and you get that wrong as well, you can find yourself facing a potential claim for 90 days pay for failing to inform and consult under TUPE, and 90 days pay for failing to inform and consult on collective redundancy, so a combined 180 days pay. And that is gross pay. And let's say you've got 100 employees, 180 days gross pay for 100 employees can sometimes get you into the millions of euros, dollars or pounds territory, and we certainly see these claims. So you've got to pay attention to these rules. And if a claim is brought, there is joint and several liability. So there's a liability is shared between the incoming employer and the outgoing employer. So both sides have a vested interest in getting this right. And once a claim has been brought, it's not that easy to settle the claims because they usually involve a large number of employees. Now, there's only a small change that the government made here, which is only really relevant to what are called micro-employers. So if you are a business that employs 10 or fewer people, so you've got to employ 10 or fewer people, then rather than electing representatives or dealing with the trade union representatives, you can speak directly to the employees about the information and consultation requirements under TUPE. Now, I know for most of our audience you will employ more than 10 people, so this will not be relevant to you, and you will be in the process of having to properly inform and consult with elected representatives. So it's a small change, helpful to small employers, with a view to taking some of the cost out of this for small businesses. So those are the 6 main changes.
So next steps to be taken in light of those changes. An obvious thing is to review standard outsourcing agreements that you're commonly using on TUPE transfers. And the first 2 points on the slide are really part of the same point, and that's to ensure that there's contractual obligations both on existing service providers and any incoming new service provider to agree and get involved in pre-transfer redundancy consultations, because that has to have the agreement of both parties, just to sort of assist things on that front where it is contemplated that there's likely to be redundancies on a TUPE transfer. Also, in light of legal uncertainty, remain robust in terms of commercial protection required if changes to terms and conditions are proposed. So that would be sort of revisiting warranties and indemnities, etc. on that front. We've mentioned about employment terms and conditions sometimes allowing potential changes. I've mentioned the mobility clause that's commonly found in employment contracts, and it's worthwhile just reviewing terms and conditions just to see whether it's worthwhile inputting similar sort of provisions which will allow some flexibility going forward in terms of making changes to terms and conditions on a TUPE transfer. And lastly, there is some new statutory guidance to assist in dealing with TUPE under the new amended regulations, and that was issued by the Department for Business, Innovation and Skills in January of this year, and it's a pretty good comprehensive guidance note with examples and things, so certainly worthwhile a read if you just want to get under the skin of the new law.
Thank you, Danielle. It's worth making the point that we've been talking very much about the TUPE legislation as it applies here in the UK. But this legislation, as Danielle said at the outset, is based on the European Acquired Rights Directive. So it applies across the whole of the EU. And TUPE is the UK's version of that legislation. I think the distinguishing feature for the UK legislation is that we have the concept of service provision change embodied in our legislation, and the UK is the only country that has that statutory provision. All the other countries have it, but it's dealt with in a different way. And the purpose of this slide is really just to emphasise that we operate across the whole of Europe, and if you do need advice on TUPE issues in any of these areas, then we can help you with it. We are now going to move on to the question and answer session, and I'm grateful to all of you who have posted questions as we've been going along. We've got about 10 or 15 minutes to look at those questions, and we have had quite a number of questions that have come in, so we're going to prioritise those by looking first of all at the 5 most popular questions that we've received, and if we don't manage to get to your question, we will be answering as many of the questions as we can after this session, but hopefully we will get through them. So please stay online for the questions, and we can probably take the first question now, Danielle.
Okay. Well, the first question is in relation to changing terms and conditions, and the question posed is that the company has recently harmonised terms and conditions. If a further TUPE transfer occurs, would it be permissible to amend terms and conditions under an ETO reason? It potentially wouldn't be. If you are amending changes and terms and conditions in order to harmonise, which of course is very common on a TUPE transfer, that is clearly related to the TUPE transfer, and unfortunately harmonisation is not a reason which the tribunals accept as falling within an ETO reason. So just the sheer wish to harmonise would not be an ETO reason, so that wouldn't be permissible, and those changes would be potentially void under TUPE now, as it would have been previously. So that's the answer to that. So harmonisation, difficult. I should add, if you're harmonising upwards, if you're improving upon the terms and conditions of the transferring employees, then that's absolutely fine. But if you're seeking to take away rights just by sheer desire to harmonise, then that would be invalid.
Thanks, Danielle. The second question relates to the point I made about the ability to potentially change terms and conditions that have been collectively bargained for after 1 year. So where you've done that with a trade union and you've got those collectively bargained for terms, after a year you can perhaps negotiate changes. And the question relates to, is it possible to, after 1 year, to make changes to individual terms and conditions of employment that have not been collectively bargained for? Well, I think this comes back to the first question too, in a way. If you inherit employees that have terms and conditions that you want to change because they don't sit comfortably with your business, or perhaps you've now got employees working side by side on different terms and conditions, I mean, the first thing to clearly state there's nothing in the law that says after 1 year you can then seek to negotiate those changes. So there is no similar requirement as there is the rule for collectively bargained terms. But what you can think about is there another reason in the future that is unconnected with the TUPE transfer? For example, you might find that you have to reorganize your business, or there's some new technology that comes in, or there's some different way of working that enables you to make some changes. And provided you've broken the connection with the transfer, so it will be sometime in the future, and for a reason unconnected with the transfer, you may be able to negotiate changes to terms and conditions with employees. And the clear things to note are that you must get their consent, generally speaking, to those changes. And I think it's a good idea to make sure that when you are introducing changes, some of which may not be entirely popular with the employees because it may be not as good as the terms they've had before, it's always worthwhile to at least offer something that is an improvement, so there's some balance in there for employees. But the fundamental answer is there's no right to change individual terms of employment after 1 year.
The next question that's been posted is this: what do the new regulations state in reference to transferring employee files? Do all of the files transfer across to the new provider, or parts of the file, i.e. contracts of employment, medical records? Well, there's nothing in the regulations, new or old, in fact, that refers specifically to files. Of course, there are the rules on employee liability information, and as I mentioned during the presentation, it's still the case that the same amount of information, the same type of information has to be provided on a transfer by the existing employer to the new incoming employer. It's still things like the names of the employees, the dates of birth of the employees, their terms and conditions, etc. And that still remains the same under the new law, except it has to be provided a little bit earlier in the process of 28 days. So that information has to be provided, but it doesn't say it doesn't specifically refer to files or anything. And ordinarily, one would expect that to be dealt with in the sort of commercial terms agreed between the parties, so to capture that sort of stuff. And it's difficult to imagine why outgoing employers would take exception about transferring that sort of information across, except I suppose where you have a service provision change and for example, the sort of service is transferring from one competitor company to another, and they're just trying to be awkward. But aside from that particular scenario, I think that generally speaking, employers are happy to give up all that sort of documentation, but it's always better just to deal with it in the commercial terms if you can.
Thanks, Danielle. I will take the next two questions. They're things I'm working on at the moment. So the first one, I think, is an important issue to flag, which is that can you have a TUPE situation where the business transfer is all done within a group of companies? So you have a group of companies with a holding company and several subsidiaries, and businesses are being transferred within that structure. Well, it's very important to recognise that, yes, TUPE does apply in those situations. So where you've got what's called an intragroup transfer, so you're moving businesses from one company in your group to another, then TUPE and everything to do with TUPE does apply in that situation. So it can often be done in a slightly more limited way because perhaps the impact on employees are not so great, but you still need to apply with TUPE obligations. So if you're doing an intragroup transfer, TUPE applies, so please remember that. The next question relates to a case called the Woolworths case. That's a very important case in the UK because I mentioned that when you're dealing with collective redundancy situations, and that is 20 or more employees who are at risk of redundancy at one establishment, the Woolworths case decided that the meaning of establishment is one company. So if in Woolworths they had hundreds of stores around the UK that were closing, and they decided to treat each store as a separate establishment. And because there were less than 20 employees in each store, they decided that they didn't need to collectively consult, and 45,000 employees were then made redundant without having any information and consultation. The employees took their case to the tribunal, and the tribunal found that actually an establishment meant the company itself, Woolworths, and that Woolworths should have informed and consulted with those 45,000 employees, who then got an award for 90 days pay times 45,000 employees, which, as you can imagine, is a very big number indeed. So the key point to take away from this, first of all, is A, the establishment for the purposes of collective redundancy consultation is the company itself. It's not each individual branch. So if you've got 20 people being made redundant across your company in the UK at 19 different branches or 20 different branches, you still cross into the collective redundancy consultation. And the point of the question is, how is this going to be resolved? Because the case has been appealed. Well, the latest situation is that the case has in fact now gone to the European Court of Justice, and what that means is we're now probably going to have to sit back and wait for a year or two whilst it joins a long queue of cases in the European Court to see how it's going to pan out. But the key takeaway point really is that if you are making 20 or more dismissals in your company, you need to think about collective redundancy consultation regime.
Another question. I'm transferring 9 people into a business of 35, including the 9 that are transferring, from a business of 2,000. Do we need to elect representatives to consult? Yes, if it does look like it is a TUPE transfer, and doesn't matter that it's just 9 employees, there's still an obligation to consult with them, and still an obligation upon the employer to basically enable an election process to take place whereby employee representatives can be elected in order for the information and consultation process to press ahead. So yes is the short answer to that.
Okay, the next question is, how does TUPE affect joint ventures where a company is not yet set up but it's going to be owned 50-50 by perhaps 2 parties? Well, I think the way to look at joint ventures is this. If you set up a joint venture with another party and employees are going to be transferring into that joint venture vehicle, then that will be a TUPE transfer. So joint ventures can attract the application of the TUPE regulations if employees are moving in or out of that established joint venture business.
And I think the last question that looks like it's been posted, it says, can I individually consult? As I mentioned earlier on, there is an obligation to facilitate the election of employee representatives for the purpose of TUPE consultation, and that rests on the employer to do that. Now, if for whatever reason the employees don't get themselves sorted in order to get those employee reps in place, then the next best thing for the employer to do is to consult individually with them. So the basic answer is the employer should basically try to ensure that employee reps are elected, but if for whatever reason that doesn't take place through the fault of the employees, then they should be consulting with them individually so that they can at least do what they're meant to do with regard to information and consultation.
Well, that's the last question that's been posted. If there are further questions that you think about later, do come back to us. But I'd like to thank you all very much for attending this webinar, and hopefully you've gained some insights into the government's changes to TUPE. Thank you very much for attending.
Thank you.